Good day, I am Trina Mendigoria and I will be presenting Articles 1540 to 1553. Moving on, let us now proceed to Article 1540. Article 1540 states that if in the case of the preceding article, there is a greater area or number in the immovable than that stated in the contract, the vendee may accept the area included in the contract and reject the rest. If he accepts the whole area, he must pay for the same at the contract rate. So this article covers the instances when the immovable sold has a greater area or number than that stated in the contract. In such cases, the buyer or the vendee may choose to accept only the contract area and reject the excess. However, if the buyer chooses to accept the entire property, they must pay for the extra area at the contract rate. Notably, the buyer cannot rescind the contract simply because of the excess area. Jumping to the next article, Article 1541, which states that the provisions of the two preceding articles should apply to judicial sales. It extends this rule to judicial sales, ensuring that both private and court-ordered transactions follow the same principle when it comes to area discrepancies. Now, let me discuss the next article, which is Article 1542. So, basically, Article 1542 addresses lump sum sales of real estate. If the property is sold for a total price and not by measurement, the price remains fixed, even if the area turns out to be greater or smaller than stated. For example, if a seller S sells a land parcel to a buyer B for 300,000 pesos, stating it's 500 square meters, but it turns out to be 600 square meters. The seller must deliver the full 600 square meters without increasing the price. However, if the seller cannot deliver the full area within the stated boundaries, the buyer may ask for a proportionate reduction or rescind the contract altogether. In case the law or the courts have ruled that boundaries take precedence over stated area, especially in lump sum sales, but when the discrepancy in area is significant or the size was key to the agreement, as in the case where a 25-hectare hacienda turned out to be only 18 hectares, the buyer may demand recession or price reduction. Okay, now let us now proceed to Article 1543. According to Article 1543, the actions arising from Articles 1539 and 1542 should be prescribed in 6 months, counted from the day of delivery, meaning the law sets a 6 months prescription period from the date of delivery for actions related to area discrepancies and or recession. Based on Articles 1539 and 1542, this encourages prompt action in protecting contractual rights. Moving on to Article 1544. So Article 1544 addresses the issue of double sales when the same property is sold to two different buyers. The law provides clear rules. Number 1, if the property is movable, the rightful owner is the one who first takes possession in good faith. Number 2, if the property is immovable, ownership is determined in the order. The buyer who first registers the sale in good faith. If not registered, then the buyer who first takes possession in good faith. If neither, then the one who holds the oldest title in good faith. An example is the case where S sells a cash register to B but allows it to remain with him. Later, he sells it again to C, who receives it in good faith. The law favors C as he was the first in possession. In land sales, if C registers the deed first and in good faith, ownership goes to C even if B bought it earlier but failed to register. However, if C had knowledge of B's prior purchase, his registration is deemed in bad faith, and B retains the superior right. Moving on to section 3, which deal with the conditions and warranties. First, let us have Article 1545. So, Article 1545 states that when a party's obligation is dependent on a condition, they may refuse to proceed unless that condition is met, or they may waive it. For instance, if a seller promises that a shipment is already en route and it turns out to be false, this constitutes a breach of warranty. The next article would be Article 1546. This article explains that any affirmation of fact or promise made by the seller that induces the buyer to purchase becomes an express warranty. Opinions do not constitute warranties unless made by someone with expertise. Moving to Article 1547, basically this article outlines implied warranties such as the seller's right to sell and the guarantee that the item is free of hidden defects. These warranties exist even if not expressly mentioned in the contract. Okay, let us have subsection 1 of section 3, warranty in case of eviction. From the law of sale, let's start with Article 1548. This article defines eviction, being deprived of the purchased thing by a final judgment based on a prior right or the seller's act. The seller is responsible even without explicit contract language, although this liability is waivable with exceptions for bad faith. For example, S sells land to B, and then C sues, claiming ownership and then wins. S is liable to B for breach of warranty against eviction because the judgment was based on C's prior right. Another example, S, the true owner, sells to B, which is B is unregistered. S then sells to C, which is registered. B can sue S for damages due to breach of warranty against eviction because the act of S second sale causing C's right is imputable to S. Moving on to Article 1549, it states that the vendor need not appeal from the decision in order that the vendor may become liable for eviction. It explains that the vendor's failure to appeal from an eviction judgment doesn't prevent liability for the vendor. The vendor, having been notified, could have pursued remedies. The next article, which is the Article 1550, meaning that if the property was already being acquired by a third party through prescription before the sale, and the buyer fails to act within the prescripted period, the vendor is not liable. For example, S sells land to B, and then C, in adverse possession for 30 years, has acquired ownership by prescription. S is liable to B for eviction. To understand it clearly, another example would be C is in adverse possession for only 25 years when S sells to B. Prescription completes after the sale. S is not liable as B could have acted during the remaining 5 years. Moving to Article 1551, if the property is sold for non-payment of taxes due and not made known to the vendee before the sale, the vendor is liable for eviction. So Article 1551 holds the vendor liable if the property is sold for unpaid taxes, unless the buyer was informed beforehand. The seller is liable for eviction if the property is sold for unpaid taxes that weren't disclosed to the buyer. Proceeding to Article 1552, the judgment debtor is also responsible for eviction in judicial sales unless it is otherwise decreed in the judgment. The article states that the judgment debtor is responsible for eviction in judicial sales unless the judgment decrees otherwise. It uses a case where a purchaser of property in an execution sale is evicted due to the judgment debtor having no right to the property. The purchaser can recover the price from the debtor. In judicial sales, the judgment debtor is liable for eviction unless the judgment says otherwise. Let us have my last topic, which is Article 1553, and stipulation exempting the vendor from the obligation to answer for eviction should be void if he acted in bad faith. It explains that any stipulation or agreement exempting the vendor from liability for eviction is void if the vendor acted in bad faith, such as, for example, knowing of the defect at the time of sale. It also mentioned that the vendee must not be acting in bad faith, such knowing of the defect at the time of sale.
So Article 1554 discusses two types of waiver regarding eviction and sale. First is consciente. Consciente, that is, the waiver is voluntarily made by a vendee without the knowledge and assumption of the risk of eviction. And second, intentionada. So intentionada waiver is the waiver that is made by the vendee with knowledge of the risk of eviction and assumption of its consequences. So what are the effects of waiver? For a consciente waiver, the vendor shall pay only the value which the thing sold had at the time of eviction. And for the intentionada waiver, the seller is exempt from liability for eviction. And this article presumes that waivers are generally assumed to be consciente unless proven otherwise. To be considered intentionada, there must be clear evidence that the vendee understood the risk and accepted them. So when the warranty has been agreed upon or nothing has been stipulated on this point, in case eviction occurs, the vendee shall have the right to demand of the vendor. First, return of value of the thing. So the vendee has the right to demand the return of the property's value at the time of eviction, regardless of whether this value is higher or lower than the original sale price. This ensures that the vendee is compensated fairly based on the property's worth at the time of the eviction. Second is income or fruits of the thing. If the vendee has received any income or benefits from the property, they must return this to the party who won the eviction suit, but only if the court orders it. This meant that the vendee can use the property without liability until a court decision is made. And third is cost of suit. The vendee is entitled to recover legal costs incurred due to the eviction, including expenses from any lawsuit against the vendor to enforce the warranty. However, this does not cover personal travel expenses related to the case. And fourth, expenses of contract. If the vendee has paid for any expenses related to the execution and registration of the sale, they can claim this cost back from the vendor. Typically, these expenses are the vendor's responsibility unless otherwise agreed. And lastly, damages and interest. The vendee can claim damages and interest only if the vendor acted in bad faith during the sale. If the vendor is presumed to have acted in good faith, the vendor cannot claim damages unless they can prove the vendor's bad faith. An example, a vendee purchased a price of land for 10,000 pesos and later they are evicted because the vendor did not have the right to sell the property. In terms of return of value, if the land is valued at 12,000 pesos at the time of eviction, the vendee can claim 12,000 pesos from the vendor. And in terms of income or fruits, if the vendee earned 1,000 pesos from renting the land, they must return this amount if the court orders it. And in terms of cost of suit, if the vendee spent 500 on legal fees to fight the eviction, they can claim this from the vendor. And in terms of expenses of contract, if the vendee paid 200 for registration fees, they can ask the vendor to reimburse this amount. And lastly, in terms of damages and interest, if the vendor knowingly sold the land in bad faith, the vendee can claim additional damages. So next, while Article 1554 treats total eviction, this article contemplates partial eviction. So if the vendee loses an important part of a sold item due to eviction, they can either ask for a rescission or cancel the contract or hold the vendor responsible for the eviction. This applies if the lost part was crucial to the vendee's decision to purchase the item. And if multiple items were sold together, the same rule applies. However, the remedy of rescission does not apply in case of total eviction as they cannot return what they received. In simple terms, if you buy something and lose an important part of it, you can either get your money back or ask the vendor to fix the issue. But if you lose everything, you can't just cancel the deal because you have nothing to return. If you do cancel, you must need to give back what you bought in the same condition as when you got it. Next, under Article 1557, the warranty cannot be enforced until a final judgment has been rendered whereby the vendee loses the thing acquired or a part thereof. In simple terms, if you want to claim a warranty because you've lost something you bought, you need to wait for a legal decision that confirms your loss. This decision can come from a court or another official authority as long as it's done correctly. How about if you buy something and later lose it due to eviction? So here the vendor is only responsible for helping you if they are officially notified and included in the legal case. This means that if you want to claim a warranty for the loss, you must make sure the vendor is part of the lawsuit. If they are not included, they don't have to do anything to help you. Now, if you as the vendee are facing a lawsuit because of the eviction, you need to ask the court to include the vendor in the case. This request must be made within a specific time frame set by court rules. By doing this, you ensure that the vendor can be held responsible for the eviction and they can defend themselves alongside you in the lawsuit. If you don't make this request in time, the vendor won't be part of the case and you may not be able to claim the warranty against them. So, if a sold property has a non-apparent burden or servitude that were not disclosed in the sale agreement and the vendor would not have purchased it if they had known, they can either ask for rescission or cancel the contract or seek compensation. However, this right does not apply if the burdens are recorded in the registry of property or if the buyer was aware of them. The buyer has 1 year from the signing of the contract to take action for rescission or damages. And then after 1 year, they can only seek damages starting from when they discovered the issue. So what are the requisites for immovable sold encumbered with non-apparent burden? First is the right of the vendee. So if Brandy discovers the hidden issues or the non-apparent burdens or servitudes with a property that were not mentioned in the sale agreement. They can either ask for the rescission or cancel the contract or ask for compensation. However, the vendor's lack of knowledge about these issues does not protect them. The contract can still be invalidated due to a mistake. Second, when a right cannot be exercised. So the vendee cannot cancel the contract or seek compensation if the burden is visible, the burden is officially registered, the vendee was aware of the burden, whether registered or not. And third is when action must be brought. The buyer must take action or for rescission or damages within 1 year of signing the sale deed. If this period has passed, they can only seek damages within 1 year from when they discovered the hidden burden. So now let's talk about the warranty against hidden defects of or encumbrances upon the thing sold. So what are the requisites for warranty against hidden defects? First, the defect must be important or serious. Second, the defect must be hidden. Third, the defect must be present at the time of sale. Fourth, the vendor must give notice of the defect to the vendor within a reasonable time. And fifth, legal action must be taken within 6 months or 40 days for animals after delivery. And sixth, the vendor must not have waived the warranty. And when do you know when a defect is important? A defect is important if it makes the item unusable or significantly reduces its value, affecting the vendor's decision to purchase. And how about when the defect is hidden? A defect is considered hidden if it cannot be discovered through normal inspection. An expert buyer may not be protected if they should have known about it. So let's give an example. X sold to Y a house. After the sale, Y discovered that the main post of the house and other interior parts have been destroyed by anay or bukbok, and as a result, many parts of the house were in danger of collapsing. And the defects of the house were hidden and concealed and were unknown to Y until a closer inspection was made by him. Under the circumstances, X is liable for the defects even though he was not aware thereof. And Y may elect between the rescission of the contract and a proportionate reduction of the price with damages in either cases. So, Article 1562 states that there are implied warranties regarding the quality or fitness of goods in two situations. First, if the buyer tells the seller the specific purpose for which they need the goods and relies on the seller's expertise, there is an implied warranty that the goods will be suitable for that purpose. An example, if a buyer asks for a paint to use on a child's room and trusts the seller's advice, the paint should be safe for that use. And second, if the goods are bought by description from a seller who specializes in those goods, there is an implied warranty that the goods will be of acceptable quality. An example is if a buyer purchases a sofa from a furniture store, it is expected to be of good quality and suitable for use as a sofa. So, Article 1563 means that if the buyer clearly defines their needs, they are relying on their own judgment rather than the seller. However, if the buyer depends on the seller's expertise, there can still be an implied warranty of fitness for a specific purpose. The article does not eliminate the implied warranty of merchantability, meaning that if the seller is a dealer in food, there is an expectation that the food is fit for human consumption. Example is B went to Western Motors Incorporation to buy a car, and after he was shown cars of different models and makes, he chose a Cougar car, model in 1982. B intended to enter the car in a race, but this fact was not made known to the seller. If the car should not run as fast as B had expected, Western Motors Incorporation is not liable because in buying the Cougar car, B relied upon his own judgment. But if the seller was informed of the purpose of B and B was assured that the car had a maximum speed of, let's say, 150 kilometers per hour, there is an express warranty for a particular purpose, and Western Motors is liable if the car should not be fit for such purpose. So, under Article 1564, an implied warranty regarding the quality or fitness for a specific purpose can arise from the usage of trade, even if not explicitly stated in the contract. This warranty reflects the parties' intention based on common industry practices. For the usage to be binding, both parties must be aware of it, or one must have a reasonable basis to assume the other knows. Without such a usage, no warranty is implied. So, in a sale by sample, if the seller is a dealer in that type of goods, there is an implied warranty that the goods will be free from defects that make them unmerchantable and are not obvious upon reasonable inspection of the sample. So, merchantability of goods sold by sample. First, where sample are not merchantable. Generally, the buyer is only entitled to receive goods that match the sample. If the sample is not merchantable, the buyer cannot claim that the good must be merchantable. And second, were sample subject to latent. If the sample has a hidden defect that cannot be discovered through inspection, and the buyer relies on the seller's expertise, the buyer is entitled to receive goods that are not only like the sample but also merchantable and free from defects. So, under Article 1566, the vendor is responsible for any hidden faults or defects in the sold item, even if they were unaware of them. So, what are the responsibilities of vendor for hidden defects? First is effect of ignorance of the vendors. So the vendor cannot use the ignorance as a defense. They are still liable for hidden defects. And the second is the exception. The parties can agree otherwise in their contract, but this only applies if the vendor acted in good faith and was genuinely unaware of the defect. And third is where the vendee aware of the defect. So if the vendee knows about the defect or any issues with the vendor's title, they cannot later complain as they have accepted the risk of the sale. So in Article 1567, the vendee has two options if there are defects in the sold item. First is withdraw from the contract. This is called action redhibitoria, or action for rescission. And second is demand a price reduction, which is known as action quanti minoris, and the buyer can also seek damages in either case. These options are mutually exclusive, meaning the buyer can choose one or the other, but not both. For claims related to damages, the vendee must provide proof of the damage suffered due to the vendor's breach of warranty.
Article 1568 states that if the thing sold is lost or destroyed due to the hidden defects and the vendor is aware of these defects, then he is responsible for the loss due to his act of bad faith. Consequently, the vendor is obligated to return the price paid to the buyer, refund the expenses incurred during the contract, and pay any damages that was incurred by the buyer. However, if the vendor is not at fault, then he is obligated to return the price paid to the buyer, the interest, and the expenses incurred during the contract that was paid by the buyer. For an example, Mr. Reyes has bought a machine from Mr. Santos, who is a factory owner. Unknown to Mr. Reyes, the machine has a defect that was known to Mr. Santos. Weeks pass after the purchase, the machine malfunctions and it becomes irreparable. In this case, Mr. Reyes can invoke Article 1568 to Mr. Santos, and he would be obligated to return the price paid, to refund the expenses incurred during the contract, and pay any damages that was incurred by Mr. Reyes due to the machine's loss. Article 1569 essentially states that a buyer could bring an action to the rescission of sale if what he had bought has a hidden flaw that makes it useless or significantly less useful than they had expected, and they wouldn't have bought it if they knew about the flaw. For an example, a family bought a new constructed house, and after months of living there, they noticed cracks in the wall due to the hidden defect in the foundation's construction. This defect substantially diminishes the house's fitness for safe and comfortable living. In this case, the family could seek rescission for the sale under Article 1569. Article 57T states that the rules governing the warranty against ordinary sales, as outlined in the preceding articles in this subsection, could also be applied to judicial sales. However, there is an exception. The judgment debtor, or the person whose property is sold due to court's order, is not liable to the buyer in case an eviction occurs. This is because the sale is not voluntary. For an example, there are two companies, Company A and Company B. Company A has judgment against Company B due to unpaid debts. The court could order a sale of one of the machines of Company B to satisfy the judgment. Mr. Lim purchased the machine at the execution sale. However, a third person claims that they are the rightful owner of that machine, and Mr. Lim should surrender it. Mr. Lim are likely to recourse against Company A to refund the purchase price and the expenses incurred. However, Mr. Lim cannot sue Company B for the damages that has been incurred because the sale is involuntary. Article 1571 establishes the prescriptive period or the limited time to take legal action, which is 6 months, for actions arising from the warranty against hidden defects in the thing sold. It specifically refers to the action based on the implied warranty against hidden defects. Other legal actions might have different prescriptive period. For an example, if the action is not based on the breach of contract but quasi-delicts or negligence, then the prescriptive period is 4 years. And with respect to the express warranty, which is the prescriptive period is also 4 years, unless there is another period that is specifically stated in the express warranty. For an example, you bought a new refrigerator. After 3 months of using it, you notice that the freezer compartment is not working. It is a defect that wasn't obvious until initial inspection. Under 1571, you approximately have 3 months left to take legal actions or claims to the seller to either repair, replace, or reduce the price for the refrigerator due to the hidden defect. If 6 months has passed after its delivery and you take legal claims against the seller, then the claims might be barred. In Article 1572, it states that if an individual buys two or more animals and one of them is defective, then he can consider returning the animal or getting price reduction. The sale for the healthy animals remains standing. For an example, Pedro bought 3 chickens and one of them has a hidden defect that makes it constantly sick. Pedro can consider returning the chicken or getting its price reduction. However, the sale for the remaining 2 healthy chickens remain the same. There is an exception for this article. It is when the buyer wants to buy the whole group together, meaning that if one is defective, it can result to the cancellation of the whole contract. For an example, Maria bought 2 horses with the purpose of breeding them together. However, one of it has a hidden defect that enables them to breed. Maria can consider returning both the horses as it hinders the main purpose of the purchase. Article 1573 states that rules governing the sale of animals as outlined in the preceding article, which is Article 1572, can also be applied to the sale of other kinds of personal property. This means that the legal principle concerning defects in animals that makes them unfit for their intended use can also be applied to the sale of other movable goods. In Article 1574, it states that if an individual buys an animal at a fair or an auction, or if it is explicitly sold as condemned, meaning it's acknowledged to have issues, then they cannot hold the seller responsible for the hidden defects that the animals might have. It is specifically emphasized in this article the principle of buyer beware. So for an example, Maria bought a piglet at a local agricultural fair. Then after weeks, she discovered that the piglet has a heart defect, which is not known at the time of the purchase. Maria cannot claim against the seller about these hidden defects because the sale occurred at a fair. In Article 1575, it specifically addresses the sale of animals with contagious diseases or those unfit for intended use as stated in the contract. So it declares such contract void. An example in cases of contagious diseases. Pedro buys a herd of pigs from Juan. Unknown to Pedro, some of the pigs are suffering from contagious disease. Under Article 1575, the contract is considered void because the animals is suffering from a contagious disease at the time of the sale. In cases of unfit for intended use, this is an example. Maria buys a racing horse from Juan, and it is specifically stated in the contract that the purpose of the purchase is for racing. However, after the sale, the horse is discovered to have a permanently injured leg, which hinders the purpose of the purchase. Under 1575, it is considered void because the horse is unfit for the intended use stated in the contract. Article 1576 states that even if a buyer has a professional veterinarian to inspect an animal and still couldn't find the hidden defect due to its nature beyond expert knowledge, then the defect is considered as retributory defect, or the one that renders an animal unfit for their intended use or diminishes their fitness, that the buyer would not have bought it or would have paid a lesser price if they had knew about the flaw. However, the second part of the article talks about the qualification of the veterinarian role. If the veterinarian, through bad faith or ignorance, fails to discover or disclose a hidden defect that would have been reasonably found, then the veterinarian is liable to the buyer for damages. It is not necessarily that the seller is liable, but the veterinarian is. For an example, a buyer buys a racehorse and appears healthy after a thorough veterinary inspection. However, after a week pass, the horse develops a rare and undetectable bone disease that could make it unable to permanently race. Even in the presence of the veterinarian expert, the disease was impossible to detect at the time of the sale, making it a redhibitory defect under Article 1576. Article 1577 establishes a strict 40-day prescriptive period from the date of the delivery for a buyer to file a redhibitory action against the seller due to hidden defect in the purchased animals. Furthermore, this article limits the grounds for such action to those faults or defects that is specifically determined by law or by local customs. For an example, Pedro buys a cow from Juan for breeding purposes. After 3 weeks of it being delivered, the cow was diagnosed with a disease that makes it infertile. If Pedro wants to file an action against Juan, then he must do so within the 40 days from the time that the cow was delivered. If he files a claim after the period, then his claim might be barred by prescription. Article 1578 deals specifically with the sale of animal. It's stated there that if a purchased animal dies within 3 days, then the seller is held responsible for their death. This responsibility could only kick in if it was shown that the illness that caused the animal's death was already present at the time of the transaction. Essentially, this article creates a presumption that if a newly bought animal dies within 3 days, the law assumes that it is more likely because of the condition that the animal already had at the time of the transaction. This makes it the seller's job to prove that the animal was sold healthy or something else caused the death of the animal. For an example, Aling Nena bought a piglet from Mang Tony on Saturday. On Monday morning, the piglet was found dead. The vet determined that the cause of the death was due to a severe cause of pneumonia that was happening for several days now. Since the disease was already present at the time that Aling Nena bought the piglet, Mang Tony is liable. Article 1579 states that if a sale of an animal is rescinded or cancelled, then the animal must return to the seller in the same condition it was in when it was sold or delivered. However, there is a crucial point. The buyer is responsible for any injury that the animal incurred due to their negligence and not due to the hidden defect that was already present at the time of the sale. For an example, Maria bought a golden retriever puppy from Juan. A week later, due to Maria's negligence by leaving the door open, the puppy got hit by a car and got a broken leg. She then discovered that the puppy has a minor skin disease and claims warrants rescission of the sale. However, Maria is held responsible for the broken leg because it is due to her negligence that it happened, and not from the hidden defect or the cause of the rescission of the contract. If the sale is rescinded due to the skin condition, then Maria must return the puppy. Maria is most likely to compensate Juan for the cost of treating the broken leg. Article 1580 states that in the sale of animal with redhibitory defect, the buyer shall also have the right for remedies provided in Article 1567. It is either to withdraw from the contract or demand a proportionate reduction in the price. However, the buyer must exercise this right within the same period fixed for the redhibitory action. Article 1581. This provision essentially states that the general rules on the forms of contracts of sale found elsewhere in the Civil Code does not automatically apply to the sale of large cattle. Instead, the specific procedures and requirements for such rules are dictated by special laws enacted for that purpose. The form of contract for such sale must be in public document.
That's it for Chapter 4. Thank you for listening.